454. The Law and Equity Act contains provisions for the unilateral waiver by a party of a condition precedent. Which one of the following is not one of the requirements? And let's get this party started. 1. The condition precedent has been satisfied. So this is not one of the requirements for a unilateral waiver. Does that make sense here? Somebody's going to waive a subject to clause, a condition precedent, and then it's already been satisfied. That just doesn't make sense. So the answer is 1. Now, these other things are requirements. 2, the condition precedent benefits only that party to the contract. 3, the contract is capable of being performed without fulfillment of the condition precedent. And 4, when a time is stipulated for fulfillment of the condition precedent, the waiver is made before the time stipulated. All right. And so the answer was number 1. Now we're going to 463. Which of the following actions will protect a seller from an insincere buyer when a condition precedent is inserted in a contract of purchase and sale? So which of the following actions will protect a seller, somebody selling their house, from a stupid, goddamn, insincere buyer who's just fooling around when we've got a condition precedent inserted into a contract of purchase and sale? And the answer to this, drum roll please, is 4, all of the above. Number 4, all of the above. And what are all of these above things? 1, state a time limit by which the condition precedent must be fulfilled. 2, talk to the buyer to ascertain whether he intends to fulfill the condition precedent. And 3, insert a clause requiring the buyer to use his best efforts to remove the condition precedent. And the answer was 4, all the above. 475. Where a buyer makes an offer to purchase land and does not pay a deposit, we all get nervous and shit our pants. Well, the answer is 3. A contract will be formed on acceptance without existence of a deposit. So this question was where a buyer makes an offer to purchase land, doesn't pay a deposit. 3, a contract will be formed on acceptance without existence of a deposit. So I guess the deposit is not the be all and all. 493. When the licensee receives a deposit in a typical real estate transaction, the licensee holds it. 493. 4, as a stakeholder. All right. So the licensee holds that deposit as a stakeholder. All right. The word is called stakeholder. That's the magic word. Not the keg, which I passed this evening, smelling all that beautiful grilled steak. So good. 501. What is time clause or 72-hour clause? These are very prompt, speedy, and timely brothers of Santa Claus, no? All right, so what is a time clause or 72-hour clause? The answer is 4. It refers to the length of time the other party has to remove a condition precedent once the clause is invoked. So that's what a time clause is, or we also call it 72-hour clause. It's number 4, refers to length of time the other party has to remove a condition precedent once the clause is invoked. You got that? Now we're going to turn over to page 8. Turning the page. Question 518. When one of the following lists accurately describes the correct criteria as agreed upon by negotiation experts for a successful negotiation. So which of the following list is needed, is the correct criteria for successful negotiation. All right, get ready, 518, successful negotiation, drum roll please. 3, efficiency, satisfaction of both parties, minimal wasted resources, preservation of the relationship. So let's go back again. We've got efficiency. This is number 3, by the way. Efficiency is needed for successful negotiation, then satisfaction of both parties, then minimal wasted resources, and then preservation of the relationship. That's 518. 535. Either party to a contract of purchase and sale may assign that contract to another party. And the answer is 2, as long as the assignment would not prejudice the interests of the other party to the contract. So either party to a contract of purchase and sale may assign that contract to another party. Number 2, as long as the assignment would not prejudice the interests of the other party to the contract. And moving right along on page 8, question 543. Conditions precedent are usually included in contracts of purchase and sale to protect the buyer. However, since conditions precedent can also be abused by buyers, a seller also must be protected when a condition precedent is being included in a contract of purchase and sale. Which of the following additions to the contract of purchase and sale is not a valid method of protecting a seller's interest? And the answer is 2. A clause requiring a property disclosure statement to be filled out can be included in the contract of purchase and sale. This is not valid. This is just not kosher. You cannot have a clause requiring a property disclosure statement to be filled out included in the contract of purchase and sale. No, and triple no. But these other things are valid. 1, a specific time within which the condition must be removed can be included in the contract of purchase and sale. 3, a covenant can be inserted stating that the buyer will use his or her best efforts to satisfy the specific condition. 4, a time clause can be included which gives the seller the right to demand that the buyer remove the condition precedent within 72 hours. So those things are valid. But this one, clause requiring a property disclosure statement to be filled out, included in the contract of purchase and sale, no way. 557, a seller refuses to acknowledge the waiver of a condition precedent from a contract of purchase and sale, assuming that the condition was made exclusively for the benefit of the buyer and the waiver was made prior to the expiry of the condition precedent. The agreement is 557.3, binding. Wow, did you get that? Let me read it again. Woo, this is like poetry to my ears. A seller refuses to acknowledge the waiver of a condition precedent from a contract of purchase and sale, assuming that the condition was made exclusively for the benefit of the buyer and the waiver was made prior to the expiry of the condition precedent. The agreement is, number 3, binding. And we're turning over to page 9, question 576. A contract respecting land or a disposition of land is not enforceable unless there is in writing signed by the party to be charged or by his agent both an indication that it has been made and a reasonable indication of the subject matter. The preceding is an extract from which statute? And the answer is 3, the Land Title Act. This is part of the Land Title Act. Let me read this boring thing again. A contract respecting land or a disposition of land is not enforceable unless there is, in writing, signed by the party to be charged or by his agent, both an indication that it has been made and reasonable indication of the subject matter. That's from the number 3 Land Title Act. Woo! Boring stuff. 580, at common law, and unless the agreement stipulates to the contrary, as soon as a contract is signed for the purchase and sale of real property, the risk of loss or damage suffered between the signing of the contract and the completion falls on, number 1, the buyer. You get that? At common law. And unless the agreement stipulates otherwise, as soon as a contract is signed for the purchase and sale of real property, the risk of loss or damage suffered between the signing of the contract and the completion, that falls on the buyer, because the buyer signed it. It's basically going towards the buyer. Buyer. Question 618. In interpreting a listing contract, the courts will, number 2, ascertain the event upon which commission is payable. Commission. Very, very important. So in interpreting a listing contract, the courts will, to ascertain the event upon which commission is payable. So the event. We're going to look at the event. It's in the listing contract. 709, in order to facilitate the exchange of possible resources in the negotiation, it is important, 3, to make concessions when necessary. In order to facilitate the exchange of possible resources in a negotiation, it is important, 3, to make concessions when necessary. So make those concessions there, baby, when you need to. And we're flipping over to page 10. Page 10. 717, Joe, a storekeeper, asked Harry, a courier. Harry? Yes? Yeah, Joe? Can you please deliver some groceries for me? Okay, Joe, I'll do it for you. So Joe, a storekeeper, asked Harry, a courier, to deliver some groceries for him, which Harry did. Which is the result? Okay, and the answer is 3. Harry could recover a reasonable amount from Joe for his services under the principle of quantum merit. Quantum merit. It is the brother of the Marriott chain hotels. No, but quantum merit, whatever, it means basically the labor should be paid. Yeah, nobody should get enriched by abusing the labor of somebody else. Okay, no motherfuckers may apply. So, Harry could recover a reasonable amount from Joe for his services under the principle of quantum merit. Yep. 718, which of the following scenarios offers neither Section 52 nor Section 74.01 of the Competition Act, i.e. neither the criminal nor civil offenses of misleading advertises? All right. So something that does not offend Section 52 or Section 74.01 of the Competition Act. And the answer is 4. A licensee advertises a Yaleton condo as 1,000 square feet, and the condo is only 998 square feet. So this will not lead to criminal or civil offenses of misleading advertising. All right? It does not offend. A licensee advertises a Yaletown condo as 1,000 square feet, and the condo is only 998 square feet. Now, these other things, they do offend. 1, a licensee knowingly misrepresents a strata unit as having 2 bedrooms but only has 1. 2, a licensee advertised a house as having a recently renovated kitchen, which is false. The licensee didn't know the statement was false and did not investigate the matter. Dummkopf. 3, a licensee posts the following advertisement on her social media page. Come check out my listings in Kitsilano family home starting at $700,000. The licensee knew that the lowest priced home she had listed started at $1 million. Liar. So in all those situations, they are liable. But if number 4, a licensee advertises a yield-to-own condo is 1,000 square feet and the condo is only 998 square feet, okay. Yeah, we'll cut them some slack. 808, which of the following is not a requirement for an enforceable contract of purchase and sale? And the answer is 1, deposit. The deposit is not a requirement. No deposit required for an enforceable contract of purchase and sale. Can you believe it? Can you receive it? Oh, okay. So we go to page 11, 846. One or more of the following statements are true. And the answer is 846. Number 3. C and D are true. Now, what is C? A court may order restitution or compensation when it decides that a contract cannot be enforced because of the requirements of Section 59 of the Law and Equity Act. A court may order restitution or compensation when it decides that a contract cannot be enforced because of the requirements of Section 59 of the Law and Equity Act. And we got to look that up when we have time. And D, this is also true. The court has the power to enforce an oral contract respecting a disposition of land if necessary, to avoid an inequitable or unfair result where the party relying on the contract has substantially altered his position. Let me read that again. D, which is true. The court has the power. I've got the power. I've got the power to enforce an oral contract. Oral contract. People still do that? Do these things? Respecting a disposition of land if necessary to avoid an inequitable or unfair result where the party relying on the contract has substantially altered his position. Question 847. You have recently listed a property for sale at 850,000 smackaroonies. An offer of 843,000 was received this morning. At noon, a second offer of 845,000 was received with a subject to financing clause. This evening, an offer of 850,000 was received also with a subject to financing clause. Which of the offers must be presented? And the answer to 847, number 1, all of the offers. 847. All of the offers. All right. The subject to financing, that is not too good, huh? You actually would have to encourage people to get pre-financed, but if that is not, if you're a listing agent, you're selling, and other people have, subject to financing, the financing can't work out. Oh man, are you at their mercy? Well, I need to ask that question. Page 12, 848, Devco Builders, a licensed real estate sales and development company, advertised in a newspaper, maybe the Sun, maybe the Province, that its deluxe condominiums come with a 10-year manufacturer's guarantee for all electrical and heating appliances included with each unit. In fact, the advertisement contained an error. There was only a 2-year guarantee available from the appliance manufacturer. One or more of the following statements may be true, and we will get to the root of it. The answer is 2. And the 2 answers is A, B, and C only are true. A, these facts represent a potential breach of the Federal Competition Act. B, Devco Builders has potentially breached the Real Estate Services Act, which prohibits the circulation of false information concerning a real estate transaction. And C, if Devco is the owner of the condo development it is offering for sale, the Real Estate Services Act requires DevCo to disclose its interest in the property to potential buyers. You got that? So the answer is 2, A, B, and C. Okay. Moving right along to 859. Section 52 of the Competition Act. Yes, we were looking for that. Prohibits false or misleading advertising and creates an offense punishable by imprisonment or a fine. Which of the following statements is not true concerning this offense? And we've got 2. This is not true. All false advertisements made to the public will constitute an offense under the provision of the Competition Act, even if the misrepresentation is not misleading in a material respect. Well, that's not true. It should be misleading in a material respect. So this is not true. But these other things are true. Number 1, the offense punishes misleading statements in various forms, including oral and written. 2, all false advertisements made to the public will constitute an offense under the provisions of the Competition Act, even if the misrepresentation is not misleading in a... No, wait a minute. Sorry, I'm getting things wrong here. Number 2, that is my answer. That is the answer to the question. And this is not true. If the misrepresentation is not misleading in a material respect. So that is not true. That's my answer. 3, I just want to mention it here. 3, this is true, but it's not the right answer. Both the general impression of the representation as well as its literal meaning are relevant in determining whether a breach of the Act has taken place. 4, the person making the representation can escape liability if he or she can show that they honestly believe the statement was not false or misleading and exercise due diligence in making sure that it was the case. So those things are true, but our answer is that misrepresentation, it's not true if the misrepresentation is not misleading in a material respect. If it's not materially misrepresenting, then maybe you get off the hook. Maybe the hook, maybe not. Page 13, 907. Section 52 of the Competition Act is a criminal offense that prohibits misleading advertisement ads. So I have learned. Which of the following statements concerning this offense is false? Again? And the answer is 3. The standard applicable in determining whether a statement is misleading or not is whether a consumer was actually misled or deceived. That is the standard. All right? We want to know if a consumer was actually misled or deceived. All right? These other things are true, actually, but they're not the right answer here. 1, a person or company can be found guilty under Section 52 when the general impression conveyed by an advertisement is misleading, even though every part of their advertisement is true in a literal sense. 2, to constitute an offense under this section, the representation must be false or misleading in a material respect. Okay, that is true. It has to be materially misleading. And 907. 4, someone accused under Section 52 can avoid conviction if they can show that they honestly believed that the representation was not false or misleading and that they exercised due diligence in making sure that this was the case. Yes, but my answer was 3. The standard that we're applying here is whether or not the consumer was actually sucked in, misled, deceived, bamboozled. Bemongla. 924. Which of the following statements about deposits is false? Wow, all these negative questions. And the answer is 1. A binding contract of purchase and sale cannot be formed unless the offer is accompanied by a deposit. No, we've already determined deposit is not the be-all, end-all. Okay, it's not the deal breaker. So that's false. And these other ones are true, and I'll just mention them for your edification. 2, where an offer is presented with a deposit check after banking hours, and the offer is refused by the seller before the banks open the deposit check may be returned directly to the offeror by the agent. Yes. 3, an agent holds deposits as a stakeholder. Yes. 4, agents are not allowed to wait until an offer is accepted before depositing deposit check in the agent's trust account. Okay? So those things are true, but the false one we had perceived is 1, a binding contract of purchase and sale can't be formed unless the offer is accompanied by a deposit. No, don't need a deposit to make the offer stick. 930, which of the following statements concerning listing agreements are true? And the answer is 4. C only, and C is all owners listed on title must sign the listing contract. All owners listed on title must sign the listing contract. This is the only true thing about listing agreements, and that was number 4. And we move right along to 932 on page 14. Section 52 of the Competition Act prohibits false or misleading advertisement. Consider the following statements about that offense. Right. The answer is number 1. Which of the following is correct? The answer is 1. All of the above statements are correct. All of them are correct. A, an element of the offense is a representation to the public, which could mean statements made by a licensee over the phone to a purchaser of real estate. So yeah, it could be by phone. B, for misrepresentation to be contrary to the act, it must be false or misleading in a material respect. Okay? Material. So A, phone, B, material. C, the Competition Act applies to both oral and written representation. Yes, oral and written is included. D, to avoid liability under Section 52, the person accused of the offense must show that he or she honestly believed that the representation was not false or misleading and exercised due diligence in making sure that was the case. Basically, you got to prove that you are a stupid idiot, lacking brain cells, needing to be admitted into the psych ward. All right? If you don't mind losing face, go ahead. Anyways, all these things are true. A, you can do it over the phone. Not do it, but I mean, you can make a statement, an advertising statement over the phone. B, must be misleading in a material sense. C, it can be oral or written. And D, to avoid liability, you got to prove that you are a fucking idiot and you believed what you were saying was true. Ha! My goodness. Get the psychologist out. Whew. Man, somebody's Darwin's zombie baby. I don't know how else to say it. 944, last one. Clive and Joyce signed an exclusive listing agreement with Lone Dove Realty Limited, quote-unquote Dove, for the sale of their jointly owned land. The agreement stipulated a price of $450,000, all cash. Graham, a trading services licensee employed by Dove, presented the sellers with an offer from a buyer for $450,000, subject to seller accepting take-back mortgage of $38,000. The sellers refused this offer, and the listing has now expired. Dove feels that it is entitled to a commission, notwithstanding that the offer was rejected. Which of the following statements is true? And the answer is 4. Both 1 and 3 are true. 1, as a prerequisite to its claim for commission, Dove must prove that it was duly licensed under the Real Estate Services Act, RESA, at the time the alleged cause of action arose. And number 3, no commission is payable by the sellers because the event stipulated in the listing agreement which would give rise to the commission has not occurred. Basically, they didn't sell the house, so hey, sucks to be you. You lose. And that's the end of 14, and that is the end of Chapter 11, Contracts for Real Estate Transactions and Law of Agency. I hope you had a great time. I certainly did.